The indictment date on this case is from September 28th of 2024.
Well, the observation, what was that? What was that about?
That's why you have a lawyer.
Your Honor, for the record, the state will be filing a motion to accumulate the sentences in these, or for the sentences in these cases to run consecutively, Judge.
So, in the September 28th of 2024 case, the allegation is that you unlawfully appropriated property, to wit, medicine and sundries of the value of less than $2,500 from John Almaguer, which is the Walmart on Dowling Road, from, again, September 28th of 2024. So you're charged in two different cases from two different dates with theft of property. One from April 28th of 2024, the other from September 28th of 2024. Again, what that means in each of those cases is if you're found guilty and those prior offenses are true, the ranges of punishment are between 2 years and up to 20 years. Do you understand? And I have here on the computer a plea bargain rejection that has your signature on it in each of these cases with that.
At this point, the defendant is making one of the biggest decisions in the entire case. By rejecting the plea offer, he isn't just asking for a trial, he's accepting the possibility of a much harsher sentence if convicted. This single choice could completely change the outcome of his future.
Because these are different offense dates, there is the possibility, if you're found guilty in each case, that he could ask me to stack or accumulate, run consecutively any sentences that you receive, and that would be up to me. Do you understand all of that?
Yes, ma'am, I do.
And do you want to reject those offers and have both of your cases set for trial?
Yes, ma'am, I do.
Okay, I will get them set on the trial docket. Mr. Coleman, is there any reason to believe there would be any change in that offer?
Absolutely not.
So I want to also make sure you understand that after today, I will not accept a plea offer in these cases unless there is some new information that comes to light that for some reason the attorneys don't know. And so if you change your mind later and want to enter a plea of guilty, it would be to something different than this plea agreement or just open to the court. Do you understand?
Yes, ma'am.
All right, and you want to go forward with trial?
Yes, ma'am.
Okay, I'll get your cases set on the trial docket. Stay in touch with Mr. Kimmler. He'll let you know when you need to be back. Mr. Savoy, you're charged in that case with the third-degree felony offense of tampering or fabricating with physical evidence with the intent to impair from September 23rd of 2023. And how do you plead to that charge?
We good?
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred adjudicated probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is
Your
there any
Honor, I apologize. One of those is forfeit the weapon as well as part of the plea agreement.
I don't think y'all wrote that on here,
Yeah, but that's fine.
and is it your understanding that also as part of that plea agreement, the weapon in that case will be forfeited to the state? Do you understand? So you won't get the gun back. You understand that? Okay. And if y'all just make sure, I don't know if you need a forfeiture motion, and I'll sign that order at
I'll
sentencing.
go grab it from Mr. Lear Court.
Okay. Is there any evidence that Mr. Savoy is not competent?
No, Your Honor.
Okay. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing at a different date, and we'll get the probation department to do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. All right, so again, you're Donald Owens Jr. And so the motion to compel, has that been worked out?
Yes, Judge.
All right, you have all the information, discovery, you feel like is out there, correct?
Yes.
Do you need me to sign that order, or it sounds like it's been taken care of? So, Mr. Owens, in cause number 24, DCCR 1192, you're charged with a second-degree felony offense of sexual assault of a child from March 29th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the computer a plea bargain rejection that has your signature on it with that of Mr. Kelly's. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 10 years in prison, which means you would be leaving your punishment up to me, and if I followed the agreement, I couldn't give you more than 10 years. I could give you 10 years, I could give you less. It would all depend on the information that was brought to me.
Courtroom decisions often come down to risk versus certainty. The judge carefully explains every possible consequence, making sure the defendant understands exactly what's at stake before choosing to move forward toward trial.
Do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, and everything's done, discovery, no, nothing, not waiting on DNA or anything like that? Okay, we'll get it set.
Everything we've asked for.
Get it set on the trial docket, stay in touch with Mr. Kelly. He'll let you know when you need to be back and ready for trial. All right, thank you.
Judge.
Okay, good morning, sir. Are you Corey Carter?
No.
And will your client waive the formal reading of the... Mr. Carter, in cause number 24, DCCR 2204, you're charged with the third-degree felony offense of deadly conduct discharging a firearm from October 13th of 2024. And how do you plead to that charge?
Guilty.
Say it, I'm sorry. Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, no.
Do you fully understand them?
Yes, no.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, no.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Without objection.
It's admitted. Any evidence that Mr. Carter is not competent?
I'm not aware of any of
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of deadly conduct discharging a firearm, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment that I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimler. All right? Good luck to you, sir. Thank you, Mr. Kimler. Thank you,
Your
Mr.
Honor.
Nichols, for getting that taken care of early. Good morning, sir. You're Paul Westbrooks?
Yes, ma'am.
And Mr. Westbrook's cases are set for trial to begin with jury selection next Monday. What is the announcement?
It's ready, Judge. We're ready on it.
Okay.
We have made a new offer. Ms. Westbrooks has rejected that offer.
Okay.
Put that on the record. Just
Sure. So I want to make sure you've relayed the offer. I know yesterday you were here and given some time to think about what that offer was. It's my understanding it was a reduction to manslaughter for a 20-year term in prison. You have every right to reject that. Your case is set number 1 for trial next week. We'll get it tried. Just want to make sure you understand. And you do, I think. You've gone over it with Mr. Vasquez. We've already been through trial, so you understand what the possible consequences are if you're found guilty at trial, correct?
Yes, ma'am.
And you want to go forward next week with trial, correct? All right, and are we going like we did last? what's the state's position on trying both cases or
We're
one
not
case?
trying them together, Judge. We're gonna try, the murder, 0329,
Okay,
23 DCCR 0329,
okay,
separately.
okay, so we will get, so for next week, it's the 0329, which is the straight murder, not capital murder.
Correct.
Okay, so we will get that started Monday, pick, jury selection at 1 o'clock.
If I may, Your Honor.
Mm-hmm.
Mr. Westbrook, you understand the state's offer. What the state has offered is the capital murder would be dismissed, and the, what's called a regular murder would be, you would be pleading to the lesser included manslaughter for a term of 20 years. And you wish to turn that down,
Yes, sir.
and you want to move forward to trial.
Yes, sir.
This may be the most critical moment of today's hearing. Even after receiving a reduced offer, the defendant chooses to take the case to trial. From this point forward, the final outcome will depend entirely on the evidence presented in court.
Those cases were reset from last week because you were going to be over in Chambers
I went
County.
to Chambers County, I spoke to them, they said they would pull the file and send me an offer. I called them the next day, they still hadn't done it. I've sent like 7 emails, I've made multiple calls, including again this morning.
Okay, so this
And
is either
they're-
going to be a plea or a trial then over here.
And I know at this point, I guess we're gonna have to set it for trial like it, because if I plea them, Your Honor, that opens them up to automatic revocation over there and much longer than these sentences could be here.
Your Honor,
So-
the state's offer, if I may, I'm sorry.
Yeah.
Yes, please.
Of the minimum of 2 years in both cases will be withdrawn if not accepted today, I previously. So
Yes, we talked about that, but-
And in addition to withdrawing the minimum offer of 2 years to run concurrent on both cases, the state will seek or file a motion to accumulate these 2 cases, meaning stack the sentences on top of each other.
I understand, Your Honor, but still, if I let them plead to this, it would automatically, it's just,
I mean, that's fine. So I want to make sure y'all go talk to him about what Mr. Coleman just said.
if you give me a second, I'll tell him that and let him make the decision.
Okay.
I know what I'm gonna advise him, but he may.
All right, I'll hold it. Y'all go visit for a minute.
Yeah, we'll talk to him.
Have his attachments, so we can't close it until we get them.
That's
So
fine. I'll get that to you.
you have to have them today, otherwise I'm not going to be able to do this in the future.
Actually, I think I can send by email, right?
Yeah, I mean, you can do it from your phone
Do it.
or your computer. That
Either
would
way, I
be,
have both of them here.
yeah, if you can get that done before you leave, that'd be great, so
Yeah.
she can close them out. Okay, again, you're Evan Bowden, and will your client waive the formal reading of the indictment in each case?
You will, Your Honor.
Get to them. Mr. Bowden, in cause number 24, DCCR 0738, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from March 6th of 2024, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In cause number 24, DCCR 1660, you're charged also with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 16th of 2024, and how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? In each of those cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. West? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection?
It's admitted in each case. Is there any evidence that Mr. Bowden is not competent?
No, Your Honor, not at all.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. And cause number 24 DCCR 0738, finds sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will